So what's happening with this case?
Judge, we've all conferred, and I think we all have a non-meeting of the minds. We all disagree on our positions. The state's position is that an offer was conveyed with a set deadline that a plea needed to be accepted, and that plea was not accepted. From the state's understanding is that the defendant is saying he didn't reject that offer, he just wanted a different offer.
Stalemate. The state says the deal's dead. The defense says not so fast. This is what happens when handshake deals meet courthouse reality.
The state's position is, since he wanted a different offer, which was lower than the state's offer, the state views that as, well, the offer was rejected then. Because the state wasn't willing to go lower than that offer. It wasn't accepted, the bargaining time ended, and so here we are. And the state has made a new offer, conveyed that offer to defense, and that's where we are.
Judge, and it's our position that he never rejected the offer. The state, when we were in there, the judge gave us the 24th of January. It's his trial date, and at that time we either accept it or reject it. If we reject it, we would start trial. However, Ms. Harrington said that she personally wanted an answer by January the 4th, whether he accepted the offer or did not accept the offer. Mr. Jones and I went and I talked to him, asked him about the offer. He never rejected the offer. The exact quote was, "I am not rejecting the offer, I am rejecting you." I contacted Ms. Harrington via text message and said that he is not rejecting the offer, that he's rejecting me. She texted back saying that, oh, so he is rejecting the offer. And I said, no, he is not rejecting the offer. He is rejecting me.
Ouch. I'm rejecting you, not the offer. That's not just drama. That's the entire case in 6 words. Was it a motion or rejection? The judge gets to decide.
Therefore, we had Mr. Jones brought over yesterday to formally either accept or reject that offer on the record. Having said that, Your Honor, Mr. Jones did, in all candor, ask if we could ask for a lesser time. I've already asked for that lesser time. That was said no to. But as the court knows, even on a trial date, we still confer. So
what I can tell you all is, one, I mean, if there is a written contract, then I can look at the written contract. But as far as me going behind plea negotiations, I really can't. What I can tell you all is that in the court's file, I set plea deadline dates. And the plea deadline date for this case was January 24th. So that's where we are. That's the court's plea deadline date. And I put January 24th as jury trial and plea deadline date. And the reason why I do that, so there's no confusion when people are saying, well, this is the deadline for my offer, unless people come to me and say, okay, Judge, we worked out a potential plea agreement, and even though your deadline is January 24th.
Judge Boyd draws the line. January 24th is real. Everything else is noise. In her courtroom, the file speaks. Period.
We're only giving them to this time. Because if that was the case, and if it would have been presented to the court, I would have put in my file, no, your plea deadline date is not January 24th. It's whatever you all say.
And that was, Judge, presented to the court. It was said to the court. We made the court aware that at the time that we were before the court last time, there was a plea deadline date, and even Mr. Porter spoke up that I had set a deadline of January 4th that he would be speaking with Mr. Jones prior to that to find out if he was accepting our offer at that time. And he would be in touch with me because I had actually asked for a time earlier than that. He had asked for a little bit longer to get past the holidays. And I conceded and gave that time. And so he said he would check in and let me know on the 4th if he had accepted our offer. And Mr. Porter did check in with me on the 4th and let me know.
All right, so this is what we're going to do. We're going to put it on the record, and everybody can put their understanding on the record, not the actual plea offer, but if people want to put what was discussed as far as deadlines, you're more than welcome to do that. Court is going to call 2022 CR 8529, 2021 CR 2489, 2020 CR 11654, 2020 CR 8810. That's a different one. All right, State of Texas versus Melvin Jones. Could I have parties announced for the record for the state?
Stacey Harrington.
For the defense?
Robert Porter.
And are you Mr. Jones?
Yes.
All right. So it's my understanding he has other pending cases, but Ms. Harrington, is your case the one that is the deciding factor in all the other cases?
To a degree, Judge.
All right. And which case is that, Ms. Harrington?
It's the promotion of prostitution.
All right. And so for the record, that is cause number 2020 CR 8810. So there is an issue with regards to plea negotiations. Is that correct?
Yes, Your Honor.
All right. So as I've said off the record, I don't want to know what the offer was, but there is some issue whether or not an offer was accepted or rejected. Is that correct?
That's correct, Judge.
All right. So States, you may proceed.
Thank you, Judge. When we were last here on December 19th, I believe it was,
Yes.
the parties conferred. A plea offer was made with a deadline on that offer. The state had asked to hear back on January 4th whether or not that offer was accepted or rejected. That was agreed to. The parties both approached the bench and said that an offer had been conveyed. We received a setting of January 24th for a trial date plea deadline, and both parties made the court aware that the state had set an earlier plea deadline, and the defense would be speaking with Mr. Jones prior to the new setting date.
Here's the split. State says counteroffers equal no deal. Defense says that's just bargaining. Who's right? Depends on whether you think plea deals are contracts or conversations.
And would let the state know whether or not that offer had been accepted or rejected. It was the state's belief that on January 4th, if the offer had not been accepted, that offer would be considered rejected and that plea offer would no longer be valid and a new offer could be made or the case would proceed to trial.
All right. And so defense, before you give me your rendition, I just have one question. So with regards to the court setting a plea deadline of January 24th, do you agree with Ms. Harrington that a different plea deadline was decided between you both?
Yes, Judge. And everybody's on the same page as that. I'm looking at my notes from December 19th of 2022. Big letters I wrote down. Let Ms. Harrington know, plea by January 4th, what his catch would be. So on January 4th, I did go to the jail. I spoke to Mr. Jones. I don't want to get into the renditions of that. That's attorney-client privilege. However, we did discuss the plea bargain. After heated exchanges, Mr. Jones looked me in the eye and said, I am not rejecting the offer. I am rejecting you. So based on that, I texted Mrs. Harrington and I said, he is not rejecting the offer. He is rejecting me. And the response was, so he's rejecting the offer. And I said, no, he is not rejecting the offer. He's rejecting me. Therefore, we came to the court to put that on the record as of yesterday for him to either formally or informally either say yes or no that I'm rejecting this offer and take it away from not it being about me, but about the offer itself. Ms. Harrington was not available yesterday, so he's here today. Now, as far as any kind of, will you ask for a different number or anything like that, that's normal course and practice for us, even on deadline dates. That's everybody's conferring at this point in time. Something may change or may not, but that doesn't mean I did not formally reject the original offer. So it's our position that that offer was never rejected, Judge. And now we're here before the courts this morning for what we do next.
Okay. All right. Any response to that, Ms. Harrington?
Yes, Judge. If he wants less time, it's back and forth. He could have asked me for less time that day, and I was told he wants less time that day, right? No, I'm sorry, he doesn't get less time. The back and forth happens, right? It's still, we're not going to go down. He's not going to take my offer. It's still considered rejected, right? And it wasn't taken. Whatever the case may be, it wasn't taken. It's considered rejected. And so the state's position is the offer as it was not taken, is considered rejected.
And again, things change. At that time, Mr. Jones right now has a sickly uncle, and the reason that he was asking me to ask the state about that is because he was seeing, is there a chance that it could be a lesser number of years so that he may be there for his uncle, that he doesn't die on him while he's in prison, if that's going to be the offer. And the attorney's going to do what their client asks. That doesn't sit there and say, if they say no, then we go back and no, they're not. So do you accept the original offer or you don't?
Plot twist. She just turned a criminal case into contract law. Meeting of the minds isn't just a phrase. It's now the entire legal test.
All right. This is what the court is going to do. Ms. Harrington, I understand that you are in a jury trial.
Yes, Judge.
You probably need to get back there quickly.
I do, Judge. I'm sorry, my phone is blowing.
No. How long do you expect your trial will last?
All week.
All right. So what we're going to do is we're going to recall this for next week, and the court will make a decision about contracts. Who knew I would be here doing contract work? Thank you, Professor Casterly of St. Mary's University. Although it's an oral contract and not written. So we'll see where this takes us. So I know your mind is probably with your jury trial. So go to your jury trial, and we're going to come back next week. So you will not be in trial this week. Okay? All right. Thank you, Ms. Harrington.
Thank you, Judge.
So, Ms. Ferguson, on this case, next week is a short week. Mr. Porter, when are you available next week?
Judge, as soon as possible, simply because the time deadline with the court also. And I need to be able to represent Mr. Jones to the best of my ability. And
No. Here's the thing. I know it's set for jury trial on the 24th. We'll cross that bridge when we get to it. But I like to do things orderly and one step at a time. So the first thing that I want to do is figure out this plea or not.
Are the courts open Monday or not?
No.
And Tuesday?
Because that's a celebration and everything that goes with it. It's a celebration and a holiday.
Well, I was confused because the court told me to show up on the 16th.
No.
So I got back to my office. I was thinking,
No, not on the 16th. Unless you're showing up to March with me.
So the 17th would be fine.
All right. So, Ms. Ferguson, can we bring Mr. Jones back on the 17th?
Yes.
All right. We're going on the record. Court is calling 2022 CR 6643, State of Texas versus Karen Munoz. Could I have parties announced for the record for the state?
John Young.
And are you Ms. Munoz?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Munoz, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Munoz, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison. Did you understand?
Yes, ma'am.
Did you understand if the state is able to prove the repeat offender enhancement allegation paragraph, then your range of punishment will be anywhere from 2 to 20 years in prison? and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as the factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
All right, off the record for a moment. With regards to an interpreter, I'm going to take that case up right after this one. Thank you. We're back on the record. Ms. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, please.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,500 fine, no application for deferred adjudication. State recommends community supervision, and there is $57 for drug testing. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes.
Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 180 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State offer, state exhibit number 1 with all of its attachments.
No objection, Your Honor.
Ms. Munoz, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, with regards to the repeat offender enhancement allegation, how do you plead to that? True or not true? I'm sorry? Did you say true?
Yes, ma'am.
All right. After reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement allegation true based upon your plea of true and based upon States Exhibits 1 and attachments. Are we proceeding with sentencing?
No, Your Honor. We're asking for a 45-day delay on the PSI.
All right. State?
States will defer to the court on the PSI. It is a agreed 5/5, Your Honor.
We told you earlier why we need a
Yes,
little bit more.
I understand that. If you want, we can go forward with sentencing. And then if there is an issue, the court still has jurisdiction.
And I would prefer, Your Honor, if we gave her some flexibility here before we impose sentence.
Okay. All right. We'll reset it for 30 days.
Thank you, Your Honor.
And the information that needs to be turned over, that needs to be done before that 30-day time
Thank you,
period.
Your Honor.
If not, then we will go forward with sentencing. What date?
I can do the 7th.
All right. We're coming back on February 7th.
To be continued. Uncle dying, lawyer drama, contract disputes, and a ticking clock. Next week. Does no really mean no?
At 9 a.m. And Ms. Ferguson will give you the reset form.
Yes.
I'll be right
No PSI.
Okay.
Ms. Munoz, if you're drug tested today, what are the results going to be?
I'm not,
I'm sorry.
no, I'm not doing.
Okay. All right. We'll see you back on February 7th.